Hey, could I get your attention? Thank you for being here. I'm Sam Panarella. I'm the Dean of the Law School, for those who don't know. And I just wanted to say, first of all, a quick welcome to all of you. Express my great enthusiasm and appreciation to the Faculty Development Committee for putting on this wonderful event. Obviously, to congratulate my colleague, your professor, Professor Chaudhry, for his wonderful new book, which we'll talk a lot about. And of course, welcome many distinguished guests. Thank you for being here. We are the public law school in the Commonwealth. I say that an annoying amount of times, but I do it for a reason, right? That we have a very particular mission here and a very unique role in the Commonwealth, one I'm really proud of. This kind of excellent scholarship is part of our mission, a very key part of what we do and who we are. And so again, I want to say congratulations. It's a wonderful day for the law school, and I'm looking forward to hearing from our moderator, who I know many of you know who our moderator is, Professor Retta, and then again our distinguished guests. So welcome everybody, and thank you.
All right. Hello, everyone. Good afternoon. I can't tell you how delighted I am to be back at UMass Law, to be here with you all and our distinguished panelists and commentators, both to be with you all again and also to get to do so in the context of talking about what I think is an incredible achievement of a scholarly book. It's an honor and it's humbling for me to moderate this set of really remarkable historians and regional experts and legal theorists, one who was my own teacher once upon a time, but also to really think about a book that is incredibly ambitious in its scope and depth, one that I'm not sure any other person could write other than Faisal Chaudhry, because it is able to draw connections across really three distinct, what we think of as distinct categories of scholarly inquiry: the development of legal theory, the colonial history of the subcontinent, the Indian subcontinent, and the kind of theory and history of empire itself. And I think not only is it ambitious, but I will say that as somebody who has taught and thought adjacent to some of these areas, and taught things that I think of as truisms, I've had to reconsider some of those in various portions of this book that perhaps I shouldn't teach those as truisms, and I may need to go back. I may need to study this a little harder and go back and reconsider. So you're here to hear from all these wonderful people, and I want to make sure we preserve time, as much time for that as possible. So I am going to tell you who everyone is, and then I'm going to turn things over right away, both to Professor Chaudhry and then to our panelists, starting with Professor Haroon. Okay, so to my left, sitting next to Professor Chaudhry, is Sana Haroon. She is a social historian interested in Islam and Muslim organization in South Asia. Professor Haroon has taught all over the world, including London, Dubai, Karachi, and Lahore. Since 2012, though, the Commonwealth have been very fortunate to claim her as a professor at UMass Boston. She is the author of several books that help to reconceptualize our understanding of governance in colonial North India, and most recently, the author of The Mosques of Colonial South Asia, a social and legal history of Muslim worship, that came out in 2021. To my right, immediate right, is Professor Osama Siddiqui, who's a historian of British Empire in India, focusing on the history of economic thought. Professor Siddiqui is an assistant professor at Providence College, currently working on a book about the translation and reception of British economic ideas in colonial history, in colonial India. And Tarana Baines is to his right, and is a historian of Britain, South Asia, and the global British Empire. Her work considers how within this empire, Britons and South Asians have debated or did debate questions of empire, statecraft, labor, and political economy. Just minor, unimportant themes like those. Her current book manuscript is entitled Instituting Empire, The Contested Makings of a British Imperial State in South Asia, 1750 to 1800. And last but certainly not least, Duncan Kennedy is the Carter Professor of General Jurisprudence, Emeritus at Harvard Law School, as a founder of the critical legal studies movement and a prolific writer with unique ability to articulate complex ideas of the moment in a cognizable way. Professor Kennedy helped shape the field of legal scholarship for really the past 2 generations of scholars here in the US. Even the people who vehemently disagree or disagreed with him, and maybe especially those who disagree, are whether explicitly, implicitly, or subconsciously responding to his work. That influence is not only national, but global. I personally have friends and colleagues drawing on his ideas in Britain, in Germany, in the Arab world, and in China. So just that scope, right? We are very lucky to have him here today. We're lucky to have all of these people here today. And without further ado, I'm going to turn it over to Professor Chaudhry.
Okay, thank you so much, Professor Rita. And all of you for being here. I see like a bunch of students, so that's very nice. And then a lot of other people, so I really thank you for that. And there might be some people on Zoom. And also thank you, Dean Panarella, for making some time to be here. And if you have to leave early, no worries. I mean, just the fact that you can continue being here for some of this is great. And I know probably kind of tough for you. Very special thanks also to Professor Lisa Owens, who as chair of our faculty development committee this year was basically the organizing force behind this event, just as she's also the force behind all the other speaker events the faculty development committee is sponsoring this year. And really to the students in the audience, I'll just emphasize that her doing so has involved a lot of hard work and effort, but also more than that, it involves an effort to bring a really vital new component to life at the law school. And it's not something to take for granted. So thank you, Lisa. And then of course, Professor Rita didn't introduce herself. As Dean Panarella kind of indicated, she's probably a professor you all, she's probably one of the professors you all were thinking, I can't wait to take her class, only to have become somewhat, or more than somewhat, crestfallen at the fact that she's had the great opportunity to relocate positions to Wayne State Law. Of course, she was here just last week. The Law and Political Economy student group brought her coincidentally for a session on civil procedure and the 1L curriculum. But of course, today she's here moderating based on her own other deep expertise and engagement with a region of the Middle East that's extremely connected to South Asia and has been, as many of our panelists will be able to indicate, amongst its connections to other places. I was asked to give a little introduction to the book to help set the stage and situate us. In an earlier version of thinking about how to do that, I had kind of more elaborate ways of expressing gratitude for everyone being here, but I think given time, I will not do that. I will just say again, I'm really excited and happy that you all made the trek out here to Dartmouth to do this. Maybe the most accessible way to situate the book for the purposes of conversation, especially one taking place at a law school, where historical analysis is not something we're doing on a day-to-day basis, is to start with something I start with in the introduction to the book. In the first few pages, I provide a quote from one of the kind of most well-known, perhaps the 20th century's most famous philosophers of the law. And I do this because I'm trying to describe in the introduction how I came to be interested in and was trying to identify the problem the book was trying to address. And then I kind of there note that amongst its key aims is to probe a question that is really more often asked in the philosophy of law, perhaps, than in history or other social science disciplines. And as HLA Hart, who's, if you haven't heard of him, think that the title associated with him is the concept of law. He's kind of the figure who revitalizes kind of positivism as an approach, to jurisprudence in the mid-20th century, along with a couple of others. But Hart notes that few questions concerning human society have been asked with such persistence and answered by serious thinkers in so many diverse, strange, and paradoxical ways as the question of what is law. So in attempting and providing my own attempt to answer that latter question of what law is, this book was one that was premised on a refusal to do so, according to what I've always felt are often somewhat canned and too sterile ways. The philosophy of law, apologies to Professor McDonald, sometimes tends to sort through that question, invariably by mentioning natural law theories and positivist theories as kind of the points of access into asking after that question, and really also invariably against the kind of presumed backdrop of Western legal development, as opposed to all the other places in the world we might start from. I think beyond that, and that brief reference to Hart, I can also say, especially since, again, I think we want to recognize that a work of history dealing with parts of the world and moments in time that are necessarily alien to kind of what we do on a day-to-day basis in the building. I think I'll also then kind of keep brief what I'll say about the kind of South Asia connection in the book, because I think that will come out. But overall, as I say on the back jacket of the book, the book is an effort to reconsider the legal history of colonial rule in British India in the period from the mid-18th to the early 20th century. So like mid-1700s to early part of the 1900s, at the point when we're within the age of nationalism, anti-colonialism, and kind of the emergence of a modern, bureaucratized, more territorial state to kind of fight over. And in doing that, the book focuses on a shifting conceptualization of the relationship between sovereignty, the control of land, if you're thinking property, and adjudicatory rectification, and basically argues for a basic movement that took place over this period, from a focus on the laws factoring into the administration of justice to the law considered as a infinitely generative norm system after 1850. And as I said, a major preoccupation in all of that is with the structure of rights talk under East India Company rule, and its grounding in an idea of property understood as control over land rent, more than as a space of dominion of the kind that liberal modernity usually projects onto property, through reference to the idea of the private proprietor, to the private individual controlling their domain. From there, the book goes on to kind of expand beyond property and think through the other key categories of private law, so contract and status, and their kind of development as concepts on through the end of the 19th century. I'll just add one more thing before turning things over to everyone here, because I think one would be remiss not to add that this one thing more is worth emphasizing in an institution whose motto is pursuing justice, and where probably it's not that common to discuss questions about law and its complicity in empire. So a final way of summarizing might just start from the reminder that this also is a book about colonialism, which, at least outside of the United States, is a word that generally carries a highly negative connotation. Of course, as that kind of work, it's not a book like, if you've ever heard of the book King Leopold's Ghost, like about King Leopold in the Congo. It's not even a work that focuses on imperial violence that you might see by a historian like Carolyn Elkins, who also teaches in the area. But still, it's a book about liberal imperialism's equivocal, two-faced, and highly manipulable commitment to the rule of law. And I think that seems apt to point out in our own world, in which it's often those who most forcefully champion themselves as the upholders of the rule of law, especially amidst recent and ongoing threats to American democracy. It's often, even as they're championing the rule of law and telling us we reside in and they preside over a so-called rule-based international order. Now, perhaps, is a moment where it's never seemed more apparent in ways that rule-based order can just as well be seen equivocally as a thin tissue of rationalizing empire and aggression by another name. So with that, I'll turn it back over.
Thanks so much, Professor Chaudhry. I don't know, so like people want to clap. And before we dive back into the substance, I will just take this moment to provide my own thank you, not just to Dean Panarella and the UMass Law School for hosting this great event, and all the staff, but also all the staff and students who have helped put this together. Even till the last half hour, people were bustling around, taking care of all sorts of the tiny logistics that make something like this happen. And a special thanks to Professor Lisa Owens, whose vision and scholarly acumen and investment in the intellectual life of this law school really has made this possible. So thank you all. So we'll start with Professor Haroun, and then we'll turn to Professor Siddiqui and Professor Baines.
Great, thank you. And it's really a pleasure to be here. I teach at UMass Boston, and I have never visited the UMass Dartmouth campus before. So it's really wonderful to be here. Thank you, Professor Owen, for the invitation. Thank you, Professor Chaudhry, for your book, which I got a hard copy of 2 days ago. It's a great addition to my shelf. And thank you for the very kind introduction, Professor Rida. So I am a historian of modern South Asia, and it is absolutely true that, as Professor Chaudhry predicts in his introduction to this book, that I have never considered the history of classical legal thought. However, Professor Chaudhry's other concerns, the fundamentally extractive nature of the colonial state and the organization of society under the law, are everyday concerns in my research and teaching. Professor Chaudhry examines law in a colonial context in which the colonizer insisted upon the logic, the rationality, the objectivity, and the fundamental justice of their mission. But Professor Chaudhry also tells us that it is not just the pure farce of the rhetoric that is significant when we consider the history of colonialism, but the very basis and imperative for the East India Company's conceptualization of private property in colonial South Asia. The East India Company's law only recognized Indians' rights to collect taxes on land for the company, conferring on them as a right an obligation to fulfill the colonial state's revenue demands, demands that were endlessly recalculable and the lion's share of the surplus on land. More simply put, the so-called rights that Indians had over the agricultural lands from which they collected taxes were distinguished by the fact that these so-called property rights did not translate into legal rights in general until after the transfer of power from the company to Crown rule. As the East India Company was conceptualizing the rights of Indians in this manner, and this is around the late 18th century, during the same time, Indian poets, religious figures, and officers of pre-colonial states were administering extensive territories that had been granted to them in gestures of patronage by Indian rulers. As much as a quarter of the territory of North India, so up to 70% of the land in Madras, Professor Chaudhry tells us, was given out in this manner. The East India Company told Indian land grant holders that they could continue to administer land, but they now had to pay tax on the land to the state, which had hitherto, under the pre-colonial states, been forgiven. The cancellation of people's entitlement to obligation-free authority and control over land on one side was compensated by the recognition of landholders' rights over the land in perpetuity. So these became proprietary rights over these revenue estates. Professor Chaudhry goes on in his book to examine changing conceptions of property and rights in the later colonial period. But I want to remain in this moment to examine what the company engendered and what Professor Chaudhry's historical study of law in this colonial context makes it possible to see. Professor Chaudhry's concern with the law is underwritten by a concern with the impact of the law on society. It's the problem of examining colonial histories without acknowledging that colonialism is fundamentally devoid of legitimacy, and the law of the company in South Asia enfolded this lack of legitimacy into its very core. When you look closely, as Professor Chaudhry directs us to, you will see the significance of the fact that it was the source of the powers of the colonial administrators, that it was the very source of the power that the colonial administrators exercised over it. The British colonizers preached the rule of law, but they themselves were crafting the law to suit their own purposes. So I'll segue here to talk about the implications of Professor Chaudhry's research for the work that I do as an historian of Muslim culture and society in South Asia, and particularly my work on mosques in colonial South Asia. In addition to conferring land grants on people, pre-colonial Indian rulers conferred large land holdings to temples and mosques, a principle that is known as waqf under Islamic law, and possibly something that you've studied with Professor Reda, I come to learn. The surplus on land that was conferred on mosques and temples provided an income for places of worship. People's rights over their land grants became permanent and proprietary in return for payment of surplus into the company coffers, but the company and its law had no means for and no will to conceptualize the rights of buildings over land. So, that surplus, which the company came to claim as revenue, had previously organized society and communities of worship. The surplus that mosques had retained under pre-colonial states funded enamel domes, marble minarets, and gold inlay in the interior walls. It provided basic civic infrastructure such as water tanks, guest houses, spaces for congregation. It made a highly decentralized civic order possible, adaptive to local needs and a local environment. Mosques, as owners of their land, were administered by elites who were accountable to society by way of people's religious expectations. The company law of property was presented as compensating Indians for the confiscation of these lands by creating a society governed by the operations of the market. But in fact, Professor Chaudhry shows us that it created, in fact, rules of property that were fundamentally extractive and tied these property owners up into their obligations to the state and not to society. Many years later, markets evolved and conceptualizations of Indian rights under law became much more recognizable as rights in general. But in this period, now moving into the 20th century, a series of legal suits were presented in Indian courts that presented non-humans, the idol deity of Hindu temples and the mosque in a city called Lahore, as juristic subjects with rights of their own in land. Historians have located this work in the legal history of 20th century India, but we may and we should trace their legal reasoning back further to the late 18th century and the moment of rupture and the introduction of a law of property under company rule that was without foundation in principles of rights as we understand them. And when the law did not deliver on the terms that it was, in the terms that it presented, it alienated society and started new ways of thinking and new ways of disputing the legitimacy of the state. We should reframe our understanding of social responses to the colonial state with a much clearer acknowledgement of the mechanics of its law and of its intent.
Thank you so much.
Great, thank you so much. And thank you so much to Professor Owens for inviting me to be part of this very distinguished panel. Professor Reda for moderating this discussion. It's really an honor to be in conversation with all of you. And of course, thanks to Professor Chaudhry for writing this really extraordinary book that's provided the opportunity for all of us to be together. It's a book that is deeply erudite, very rigorously and powerfully argued, and transformative of the way in which we think not just about South Asian legal history and the history of the British Empire, but also the history of law and jurisprudence more broadly. I'm not a legal historian, but I have to say it really was such a pleasure to engage with this book, and I learned a lot from it. I also want to say that it's really impressive to read a book in which the argument of the book and the method of the book are just so brilliantly linked together. Because what this book offers is not just a kind of sort of ambitious, big new argument about how something called the law emerged in South Asia, but it also offers a new methodological approach of historical ontology, which I'll talk a little bit more about towards the end, for understanding how this law, how something called the law came about. In doing so, I think this book represents a landmark intervention in the history of law and legal modernization in South Asia. So legal histories of South Asia, I think, have sometimes tended to focus on legal institutions or legal mechanisms, everyday forms of legal practice, or looking at particular issues through case law. In contrast, this book asks and answers a more fundamental question of what actually is this thing called the law. And as the book compellingly argues, we have so naturalized this concept, this object in our thinking, that we haven't really considered its historicity, all of the ways in which it's historically and discursively produced. So in the time that I have, I want to summarize the main argument of the book briefly, and then highlight what I think are some of its main interventions, and then bring up a couple of questions for reflection. I'll note that while the book's focus on South Asia's legal modernization focuses on South Asia's legal modernization through the law of property, contract, and status, I'll focus mostly on the question of property, though I hope we'll have an opportunity to explore some of the important questions about the law of contract and status that the book brings up and that Professor Harun alluded to already. So broadly, this book explains the emergence of the law as quote, and I'm going to quote a little bit from the book, as a supposedly self-contained and purportedly infinite system for normatively classifying the facts of the world, end quote. So as this pertained to the law of property, the book argues that in the early phase of the East India Company rule of India, the focus was, quote, on the laws, in plural, relating to the administration of justice, rather than on the law as a comprehensive normative system. In this phase, so the company's focus was more on rights to land revenue, rather than on physical control of the land. So in a lot of other scholarship on this period, it has sometimes been sort of described that the company's land revenue policies or rent policies differed in the various parts of the company's domains, or also called the company's presidencies. This book argues instead that there actually was an underlying similarity to the logic in which land rent was the focus across Britain's India, and the way in which the law across these different areas focused on the rent rather than on kind of who physically controlled the land. After 1858, when there was a shift from the East India Company ruling to the British Crown itself becoming the sovereign, a number of changes came about that transformed this conception. And Professor Chaudhry's book looks at both what's happening kind of in legal philosophy and jurisprudence, but also what's happening at the level of imperial political economy. So in legal philosophy, there's a rising influence and globalization of classical legal thought. But in the political economy of empire, there's also a shift, somewhat of a shift away from land revenue as the sort of most significant piece of the company's rule. In a context of increasing commercialization and monetization of agriculture, credit became more central to the task of extracting the agrarian surplus. And it's in this context that the law emerged as a kind of unitary object that Professor Chaudhry looks at. As he argues, this entailed an expansion of proprietary rights. So in the post-1857 period, there was an expansion of proprietary rights that came to be aligned with a kind of general idea of legal right. I think one of the main implications of this argument is that it really transforms how we think about the legal history of property and land control in South Asia. So a sort of typical received story that many historians of South Asia have studied over the years is that the shift from company to crown in the middle of the 19th century led to a kind of intensification of revenue demands and surplus extraction. Against this sort of typical story, this book argues for a sharper break between the period of company rule, so before 1857, and crown rule after 1857. particularly from the perspective of property relations and land control. As the book argues, after 1857, it was not just that land revenue demands were becoming intensified, but actually that property itself was becoming internalized into the law. A second major way that I think this transforms the study of property and land control in South Asia is by sort of pluralizing the discursive sites that we study. So histories of land revenue in South Asia have often tended to focus on, on what Professor Chaudhry calls that kind of extra doctrinal and administrative discourse. So in a lot of the work, we find out what different thinkers thought about property systems.
Right.
And what the kind of colonial state thought of the land revenue, the property systems, rather than what Professor Chaudhry calls the law's own talk. So how did the law sort of reflect on itself? I think one of the effects of this in the historiography has been that we have perhaps overemphasized the political and ideological differences between different schools of thought. So for example, we've tended to assume that liberal thinkers in the early 19th century had a particular conception of land revenue, or that utilitarian thinkers had a particular conception of land revenue, or a certain type of orientation to the land. In contrast to this, this book shows that actually, despite their much touted oppositional focuses, many of these philosophies in the pre-1857 period had a kind of underlying similarity on focusing on the rent, the revenue of the land, as the main lens through which to think about property. And I think this is a really very significant rethinking of ideological differences in the making of colonial power. I want to turn now to some sort of questions that this book has sparked for me, and has sparked many questions. There's a couple I want to think about, and I'm sure others will have more questions as well. One thing I'm interested in thinking about is, to what extent does this book help us to make sense of new and intensifying forms of land control and extraction, particularly at resource frontiers in the late 19th and 20th centuries, in the late colonial and post-colonial worlds, that became central to sort of global energy regimes in the 20th century, but certainly in our own times as well. The expansion of resource frontiers and the intensification of extractive economies that have been accompanied by processes of agrarian dispossession and all sorts of legal and extra-legal methods of land grabbing. How does the history that Professor Chaudhry details in this book help us to make sense of how the emergence of the law has facilitated this process of dispossession? I'm thinking here in particular of another historian's work, Matthew Schutzer, who works on this area, particularly on the legal and political ecology of coal mining in India. Schutzer argues that starting in the late 19th century, when coal mining began to boom, a key question that emerged was who actually owns the subterranean property? Who actually owns the coal that is under the surface? Is it the party who owns the land who owns the coal? Is it the party that leases the land who owns the coal? Schutzer argues that courts in India answered this question by reinterpreting and examining zamindari customs, which was the kind of system of land revenue and settlement under company rule, to accommodate claims of mining companies within existing legal jurisprudence on land. As he puts it, and this is Schutzer, this was a kind of recursive conception of law that emerged out of dispossession produced by mining rather than preceding it, suggesting basically that property regimes in this sense were born outside, sort of produced by capital. So the sort of the dispossessions produced by mining capital produced this kind of property regime dealing with subterranean properties. In many ways, Professor Chaudhry's book helped me to make better sense of this history. I think the arguments of this book really complement Schutzer's narrative. And I think we can situate this question of who owns the coal or who owns the subterranean property within the context of what Professor Chaudhry describes as the sort of very widespread expansion of proprietary rights and a concern with deriving legal rights from a right of property that he details in the second part of the book. Yet at the same time, it seemed to me that the question of how property should be defined, whether as control of the physical land or as a right to the produce of the land, continued to be operative, particularly now that the produce referred not just to sort of what was cultivated on the land, but also what was underneath the surface. So I'd be curious to hear Professor Chaudhry say a little bit more about how these new types of extractive property regimes relate to, complicate, or support this really powerful narrative that he has given us. My second and more general question has to do with questions of method. So one of the unique and really powerful methodological interventions of this book is the method of historical ontology. In particular, the book makes a distinction between what it calls doctrinal discourse, which is propositions of the law, and ordinary language discourse, which are propositions about the law. And the book shows in a really compelling way how these two, the doctrinal discourse and the ordinary language discourse, came to be increasingly linked and kind of mutually enforcing in the late 19th century period. As an intellectual historian, I'm really curious to hear about the extent to which this method can be applied to other types of intellectual history, to perhaps non-legal intellectual histories. In some ways, I think the brilliance of this book and the brilliance of this method is to avoid this dichotomy between theory and practice that we sometimes fall into when we write intellectual histories. I think I've sometimes fallen into this myself. So I'm really curious to hear about how we can use this method to other works in intellectual history. At the same time, it also seems to me that there is something unique about the law and how it operates in the world as a system of doctrinal propositions that particularly lends itself to this method. So I'd be curious to hear Professor Chaudhry say something about whether you see this method generalizable to other types of intellectual history, or if the law itself is particularly suited to doing this kind of work. So I'll stop here and look forward to other comments and questions. Thank you again for the chance to engage with this really incredible work.
All right, so as is customary, I'm going to begin by thanking Professor Owens and also Professor Ritter, and of course, all of my fellow panelists. I'm very grateful for the opportunity to discuss Professor Chaudhry's important and rigorous new book, South Asia, the British Empire and the Rise of Classical Legal Thought. So as many people have already pointed out, this book raises a number of foundational questions. It asks the question of what exactly is the law. Importantly, it tries to answer this question by taking a step back and also asking how, when, and why did a singular, discrete conception of the law, as opposed to many laws, emerge in British India. Moreover, Professor Chaudhry doesn't simply focus on the emergence of the law. This book is also equally focused on the emergence of the state and the question of what the state was. Following on from the Austrian jurist Hans Kelsen, Professor Chaudhry considers the relationship between state and the law. Does the law produce the state, or does the state produce the law? If the state and the law are co-constitutive, how does one go about conceptually distinguishing between them? To further complicate matters, this book deals with a time and place where the configuration of the state or states in question was especially complex and confusing. The book covers more than 100 years of lawmaking as well as state making in the geopolitical entity that eventually becomes known as India or British India. In the process, the book tracks the shift from something called company rule to something called crown rule in 1858. It does so by considering transformations across multiple levels and scales of analysis, including metropolitan parliamentary legislation in London, in Great Britain, institutional expansion and change within the presidencies or governing units in South Asia, or what is now modern India and modern Bangladesh, as well as everyday administration within these units. I'm going to take a few minutes now to explain the term company rule so that you can make sense of the stakes of this book, as well as understand the difficulty and ambition of the task that Professor Chaudhry has undertaken with writing this. So the company in company rule is, of course, the English East India Company. The East India Company was first chartered in 1601 by Elizabeth I. So there's a very long history here. And obviously the Dutch and the French and others, the Swedes, also have their own East India Companies. The company's charter didn't simply state that the company had the authority to trade with the so-called East Indies, which, by the way, were defined as all regions east of the Cape of Good Hope. So it also included China or Southeast Asia, not just South Asia. The charter also specified that the East India Company would enjoy a monopoly over all English trade with the East Indies. This meant that if you were English and later British, you had to have an affiliation with the East India Company in order to be able to directly trade in really valuable commodities like spices, textiles, and tea. As you can imagine, the company's monopoly wasn't especially popular among all sections of society. British colonists in North America in the 1760s and 1770s weren't thrilled, hence the Boston Tea Party. but there's a long history of this going right back to the 17th century. The periodic renewal of the company's charter, roughly every 20 years, inevitably meant that people would gather to talk about the merits and demerits of such a monopoly. By the 1750s, the British presence in South Asia wasn't narrowly commercial or focused on trade. In the 1740s, in the midst of the global war of Austrian succession, the English East India Company made major territorial gains and actively participated in warfare, often against French troops, but also local states. So this is a company which also commands an army. By the end of the global 7 Years' War in 1763, often called the French and Indian War in North America, British political authority in South Asia had grown even greater. Hence the commonplace emphasis on the British victory at Plassey in 1757 and eventually in Buxar in 1764. These military victories and British territorial expansion further sharpened the long-standing debate over the authority of the East India Company to manage large swaths of land, collect revenue, and perform various state-like activities. British politicians and the British public also returned to the long-standing question of whether it was acceptable for such a company, a corporation, to maintain a monopoly over the trade with the East Indies. Why should the majority of British people be left out of the ability to trade with such a commercially vital and dynamic part of the world? And so at the same time that a new colonial state was emerging in South Asia, British politicians and the British public spent massive amounts of time engaged in a contentious debate about the relationship between the company and the British state, which included institutions like the King himself, George III, and Parliament. Some asserted that the company's property rights must be respected and that the British state could not confiscate something that belonged to a corporation. Others argued that the company had never in fact been independent of the British state, and the British state could take away a charter the way it had granted a charter in the first place. In other words, that the matter of the company and the company's monopoly had nothing to do with property rights. Indeed, both Edmund Burke and Adam Smith, major political as well as intellectual figures in the late 18th century, argued for dismantling the East India Company, albeit for very different reasons. Whether people argued in favor of the company's rights or against it, they invoked the Constitution of Great Britain. Now, this might seem like a weird idea. What exactly is the Constitution of Great Britain? It certainly isn't something that we think of the written document, right? But people in the 18th century are regularly talking about British constitutionalism and what the British Constitution is, including colonists and settlers in this part of the world in the 18th century. They too are invoking the British Constitution, especially in the lead up to the American Revolutionary War. Some during this point in time made the argument that the company existed as a check on the power of the British state in India. Sorry, the power of the British state back in London. If the British state based in London directly governed India, it would become so powerful as to itself become an Oriental despot. So for some, the East India Company became a way of preserving checks and balances, right? Whereas for others, it was sort of egregious that a company could be in charge of other parts of the world. So even before the official transfer of power to the crown in the year 1858, lots of British people were actively arguing about the possible abolition of the East India Company and thinking about what it might mean. To muddy matters further, plenty of company officials and directors of the East India Company served in the Parliament of Great Britain. So you have a really complicated situation here. So having laid out all of this, I'm going to now pivot to posing some questions. So one of this book's major contributions is to highlight, and I think Osama has pointed this out, how the right to property was envisioned not so much as inhering in the soil itself, but in the rent generated by a particular piece of land. So given this emphasis on the precise way in which property was constituted in South Asia, I wonder if one can tie together the discussion of the company's property rights that was happening in Britain, but also among British people in South Asia, to the discourse around property within Bengal and the Madras presidencies. In other words, how did arguments emphasizing the inviolable property rights of the East India Company, as well as those who rejected the company's claims, inflect the project of defining property in South Asia? And one might even perhaps think about how similar discourse around being taxed or how property works in North America in the 1770s and 1780s inflects much of this debate. One of the major figures in this book is Charles Cornwallis, who might be familiar to you as the general who leads British forces here in the American Revolutionary War. In the mid-1780s, he gets appointed as the Governor General of India. So here is someone moving across these two very different parts of what was once the British Empire and what is becoming more and more part of the British Empire, right? And I think you see these obvious connections among people moving across these different parts of the world. And so I think it's interesting to maybe ask this question of how property is being envisioned in North America, as well as India at the same time. I also think that this issue of the company's charter is perhaps important for thinking about how British settler colonies and non-settler colonies fare over the longue durée. Because arguably it's the company's charter that prevents people from just moving and settling in large numbers in places like Bengal and Madras. So arguably India's status as a non-settler colony is also constituted in the law. And so I'd be curious about what you make of that and the sort of absence of British settlers, or the large scale absence of British settlers who might be demanding property rights of their own. And on that note, I think it might be interesting to put this book in conversation with new books like Christian Brissett's Empire of Laws, as well as Lisa Ford's book, The King's Peace, which studies many different British colonies that don't exactly look the same. Studies Jamaica, Bengal, as well as New South Wales, which is also being set up in the late 18th century. I also wondered if you could perhaps say more about the conceptual apparatus of the 18th century. You note that it's only later in the 19th century, in a sort of more high imperial moment, where we get this much more expansive vocabulary of protectorates, mandate territories, and so on. But I also wonder about more 18th century terms, such as double government, which a lot of British figures use to talk about how South Asia is being governed in between the company and the crown, or the idea of union, which is an important way for people to think about how Scotland and England create Great Britain. But it's also one of the ways in which proponents of the abolition of the company talk about how India might be incorporated into the British state through a union. Or equally terms like empire within empire or imperium in imperio. And here I wonder if the sort of counterexample of Ceylon can be instructive. The fact that the Dutch colony of Ceylon gets incorporated into the British Empire in the early 19th century, but not as a territory administered by the East India Company, but directly as a crown colony. And if the trajectory of law there looks different, and I don't know the answer to that, but I'm sure you have plenty of thoughts on that point. And my final question and thought would be about the category of military rule or martial law. And I'm thinking about this partly because when Charles Cornwallis is appointed Governor General of India, he's also appointed as the general leading the king's troops in India. So you have this weird braiding together of civilian command and military command, at least in the figure of this one Governor General. And obviously the specter of martial law is hugely important throughout this period, especially then in 1857. So I wondered how you see that other category of law fitting in with your broader narrative. So I'll stop there and very much looking forward to the conversation.
Just before I turn things over to Professor Kennedy, I just want to note that there are cards. If you do have comments or questions that you might want them to answer, you can write those out now.
So it's a great pleasure to be here. I strongly endorse the idea of public law schools, although I teach in private law school. And also I'm very grateful to the dean, Lisa, to you, for organizing the panel, which was no mean feat given the diverse institutional affiliations. Here's the question that I propose for us. So what does any of this got to do with law as we study it in a typical American law school? So it seems extraordinarily distant in the details of what it's about. So how is it possible to relate it to what goes on in the classroom? I mean that actually in the classroom, say here. So as a way to try to figure that out, I think the first question I want to ask is how many of you were students of Professor Chaudhry? So how many of you have taken a first year course in property from another professor? So this question would be something like this. How is Professor Chaudhry's book related to the way he teaches property at UMass Law today? So I think it is possible to answer that question and shed some light both on his book and on the teaching of law and the way law works in the American context. So this is addressed. So now I think the way to look at this would be to say, his book makes a claim that there's something called legal consciousness, which can be studied. And it's not studying the truth of what you're conscious of. It's studying how you can organize your thinking, what concepts have reality for you. So probably for most of the law courses that you take, a very basic idea is what you might call the idea of the law as doctrine. And it's called this doctrinal study, and you understand the teacher as a doctrinal teacher or not a very doctrinal teacher. The doctrinal mode of study starts from the idea that the law is there. You approach it as something that's outside there, that's full of reality for you. And a case involves a dispute about the law, which will be a dispute about how to apply a rule to facts. But most of the cases in the casebook are actually involve a question of law rather than a question of fact. So the case is about which interpretation of freedom doctrine ought to be adopted by the court. So should the court decide, let's say, that the owner of the subsurface rights that contains coal can sell the surface rights to someone else who will then own the surface rights, but not the subsurface rights. And that if in fact the subsurface coal owner wants to remove all the coal, which will cause the surface land to collapse, that's part of his property rights. So the answer to the dispute how to interpret the rule is it's not, the rule doesn't require the subsurface coal owner to actually pay any attention to the consequences of collapsing the surface rights of this other owner. Now, are any of you familiar with this famous case? So you guys are not. This is a very famous case because it's in the United States a constitutional question, not just a question of how judges doing the common law are going to decide it the way it happened just in a normal Massachusetts court, but or in that case, the West Virginia court. It's a question of how the U.S. Supreme Court will decide that question, which means that the question is understood that the answer that flows from the phrasing of the Constitution. The law of the Constitution is law, and what the local court does must correspond to what is required by the Constitution. And the court basically, all the lower courts reach the conclusion that it's built, all but one, reach into the conclusion that the very constitutional right is the thing that determines what the property regime has to say about whether when the subsurface owner removes it and collapses the land, he can do it without being responsible in any way for the consequences. So this is an example, let's say, of the category of historical ontology, which Professor Duncan said is a crucial contribution, is indispensable to understand this, because the way the Constitution and the property and subsurface property and surface property are understood and connected to each other. So the right to not be deprived of property without due process can be translated into micro rules of doctrine about surface and subsurface owners. And those micro rules of doctrine can be are compulsory because it's source right here, and they control what's going to happen. So the experience of the student is you're confronted with one of these situations of the case, and you have to learn what happened. And the basic way you learn it is to understand how it makes sense. So the enterprise of the student is to make sense of the outcome. Now, that creates an immediate tension for almost all students. So take in this case, if the case is taught by a professor who wants to generate anxiety, the way that can be done is to point out that the owner of the subsurface bought the land with a coal, and then they sold the land to the surface owners for the creation of a town in plots some of which were for schools, some of which were for the town hall, some of which were for the fire department, and many and several thousand individual households. So, and the company owns and still owns all the land. So they use their land ownership to sell a surface to create a classic company town, in which they were the overwhelming main employer, owning all the stores as well as having provided the land for these purposes. So the consequences of what the company decided to do, this was not a dispute between individual landowners, where you imagine, I want coal because I'm going to sell it, and you know, I sold you the surface and you got a house on it. That's an interesting, complicated question. Here the question was, they decided to mine out all the coal. So having decided to mine out the coal, they basically decided to eliminate the town. So now, how is that going to be addressed? The background consciousness that whose emergence he's describing in India is also the background consciousness that had emerged in the United States before that. So there's some sense that what's happening in India was the incorporation of India into a mode of thinking about law that existed in England and in the United States, and that was globalizing all over the world. And the essence of that way of thinking about it, according to Faisal, was in a situation like this, the Constitution is real. It's like an object. It's like a thing that can be analyzed. It has parts which are related. It has consequences that flow from it, from what it is. And those consequences are, they are the way things have to be. If you believe in the Constitution, you believing the Constitution is to believe in the legitimacy of norms, of rules of law that the judge in this thing's case is going to derive the property of the company versus the property of everybody in the town, including the town government. So when we approach this, in the classical consciousness, it's a deep search. It's a search for what is immanent or dwells within as an ever-renewing source of norms that are experienced as legitimate. It's the inquiry to find them. It's in there, and we're looking to find it. So I think it's unlikely that those of you who had Faisal, if you have a case, you didn't have this, you missed the case because of the best case in probably my the single best of all conferences. So it would be very unlikely that you would approach this case on the kind of premise that we have to understand what understanding the Constitution to be true, coherent, real, and having infinite consequences. That's what we're trying to decide when we discuss the case. So the consciousness that he's describing, that which you do approach it, you do understand it, was the product of historical. It's the creation of an intellectual thing that is real to us. The Constitution and its consequences. Out of what? Well, the basic premise of historical ontology is you don't assume that it was the truth of that it is the truth of the matter. That the object here, law, actually could be constructed in many different ways. So ontology is being, so this being, which understood as being, comes into existence through a complicated historical process. And when you look at it that way, an activity comes into existence. And the activity is to criticize that, to criticize the idea that the Constitution has this quality of being that allows it to tell you what to do about the case of the townspeople versus the Pennsylvania coal, which is, you know, the monopoly employer and landowner of the region. So it suggests that it can't be right to start from the idea as a critical studies, which is striking practitioner, the crit approach just doesn't start out accepting as a premise that there is a constitution that is an infinitely generative source of new normative resolutions for any problem that might exist with social conflicts, but no. So first of all, there's a deep skepticism that you could possibly have those qualities, which is reinforced by an activity which is to criticize it, to show that there are contradictions and ambiguities and indeterminacies in constitutional discourse. So when you read the dissent, in this case, the dissent is it's a famous dissent. The dissenter, if the course is done in the most conventional way, you can ignore the dissent, because all you as the student need to figure out is what the reasoning was for the majority opinion. And many first-year students in many law schools, including Harvard, started out with the idea that you can ignore the dissent. You only care about the law. In the crit version, the dissent is offered as an illustration of the reasoning of the majority wasn't how it had to be so. There was an alternate reasoning, which is already there in the dissent, because a good dissent, as it's here, it shatters your sense that it's being decided by the Constitution, speaking for the mouth of the judge. So something else that is ideas about which politics, ideology, what is fair in the overall political system are somehow strongly influencing even the most conventional legal decision that seems just cut and dry as nobody could possibly dispute. So my bet is that in the law school classroom, you'll find a kind of complex division in the reputations of first-year teachers over how they teach, whether they are maternalists operating within the classical legal consciousness that is described in India, or whether they're operating from the consciousness that succeeded it for many, many practitioners, which is one that sees the law as mediating conflict with an element of just deciding it, not completely internally, but with some very complicated, hard to take, or vulgar external influence. So it could be a very, very complicated thing, but it could be gross. Now, in this case, at the trial level, it was gross. The judge was basically owned by the company. By the time it gets to the Supreme Court, it's really complicated, because the majority opinion in the city are the leading thinkers about law of the moment happen to be Supreme Court judges. And that has not been true for many, many years. But that meant that's what it was like. So there, his book is an illustration of how in one locale we got to this point where not just in India, in the United States, in Britain, but in Ceylon. So if we're talking about Ceylon, it's the same. A different process, it's the same. If we're talking about even Egypt, it's the same. The outcome is classical legal thought. And the outcome is a critique of classical legal thought that is equally shared, and which is institutionalized in American law faculties. This will be student evaluation, doctrinal teacher, policy teacher. Is he a doctrine teacher? Is she a doctrine teacher? Policy. So that represents two different historical consciousnesses that are related to each other. They have origins, both the origins here, and they have implications today also across the world. So the book is an incredible accomplishment in tying the, I've just tried to tie together what the book ties together. In other words, the book is about the emergence of consciousness that I just described. So I say, I would read the blurb. Do I have still a minute?
You have still a minute.
So let me read the blurb.
And we do talk about that case, actually.
I suspected that was coming.
So Duncan said it's a brilliant rereading of the legal history of 19th century India and the British colonial rule. Chaudhry shows that both before and after the shift from company to crown in 1857, the legal consciousness informing the creation of new law changed continuously in ways that was important, and more important than changes in legal substance. A highly original and deeply researched investigation to where law did and didn't travel from the metropole and was transformed in the process. An important contribution to the jurisprudence as well as comparative law and critical legal theory. I just gave you the critical legal theory. So thank you so much.
Okay, I'm gonna let you pick your own adventure, Professor Chaudhry, because the panelists really gave you quite a few excellent questions. And you might want to get a chance to think out loud with us about some of them. But I'm gonna add my own on because Duncan Kennedy said something that I thought was very provocative, whether he meant it or not, he usually means it. Which was, I'll tell you about Ceylon, it's the same.
Yeah.
Maybe. And I don't mean that as, no, it's not, but if it is the same, then why do we care that it developed differently in company India? Under company rule.
Yeah, I know we're in our waning minutes, as tends to happen with these things. So there's not gonna be enough time to do justice or discuss. In a way, it's helpful for me because the questions, I think the questions the first three of you raised, I mean, I'm sitting up here kind of sweating bullets because I can't really answer all of them. And I'm realizing that my research efforts would be revealed to be nakedly inadequate because I really can't think of them. I did also like though Duncan's comment to Rana's raising of Ceylon, like contemporary Sri Lanka, because it highlights maybe a difference between Duncan as a type of legal historian, who historians, I don't think you'd be okay with me saying, would not accept within their ranks as a proper historian, and kind of the temperament of the historian who probably is always inclined to push back on notions of uniformity and similarity. That usually is coming at history from some angle of theory, like maybe historical sociology. We even, even the references to the idea that there's a kind of a core in England and America and sort of like what's outside of the core in India. These days, within the writing and professing of history, that kind of idea is sort of unpopular. And you can see kind of why. There's compelling reasons why it would be, because in some sense it still maps kind of the beating heart of historical processes on what's happening into this supposed core, in relation to which everything else is kind of a margin or something. That's very much not the type of question historians who are insisting instead on connected processes and also wanting us to visit the past as another country that you can't understand simply through reference to how things turn out, like at the point when we're looking back and it's seeming like there is core versus periphery relationships. That's kind of not the temperament always of the historian who wants to push back. But I think that's productive because I think even if met with that concern, someone like Duncan, and I am partial to what he's saying, I think the professor read his question, would kind of push back and insist that in a way it is the same thing happening through a different process. So there we're within a kind of methodological processual dispute on how to sort that out. I guess I'm in a way torn between these two things because going back to the first several questions, I'm sweating bullets because I'm realizing in part that I can't answer these questions because I don't have a good enough sense of the specificity. But then in terms of some other commitment, I'm also on Duncan's side because I do think, like, I wouldn't have written this book invested in the category of classical legal thought if I didn't think there wasn't something deeply uniform going on. Partly simply because I'm perhaps under the influence of how he himself has conceptualized some of this as well. So I guess I would just maybe say, I don't think I can answer these questions, but they're great questions. I think they obviously hopefully have surfaced some resonances. Rent, what is rent? What is rentierism? If you're thinking about extractive industries, that anytime you hear about that in today's world, you can't not think of the notion of rentierism, whether you exactly are familiar with that term or not. And in a sense, I'm trying to trace an alternative history of the foundation of legal rights as linked not to political and economic freedom as kind of the hero story of the rule of law and kind of the making of the modern world, but kind of a different, kind of the underbelly of the right to property as the emblem of a kind of extractive, exploitative, if you like, rentierism. So the excellent, amazing question. I think Tehran is raising many herself. I kind of touched on how, kind of what it had me thinking about in terms of this a kind of dilemma of how to tell a connected history, but then maybe still be invested in the idea that somehow the world has become, in a way, a more uniform sort of place, and it does seem to have core periphery kinds of relations. I think Sana had me thinking as well, and kind of moving us back and forth from the kind of late 19th century, sorry, the late 18th century to the 19th century of thinking through kind of the other end of the making of the law. In a way, like I'm kind of arguing for like a constructivist argument, but at the end of some road, something is constructed and you're left with what's constructed. So that's kind of a different way in. And certainly one type of reaction of the law student or anyone else to kind of what Duncan was describing, and I'm interested in tracing the evolution of this consciousness, is the reaction you can always give to any historical intervention. So what? Like, you know, history made us the way we are, and then we move on from there. So I guess in that respect, I'll just end by saying, I think there is something worth it is worth being invested in, like a denaturalizing outlook, and to not take apparent givens as givens. And definitely in the first year classroom, I think that surfaces as a type of conflict. So if you're a law student, I think it's worth kind of trying to think through a little bit more what a historical context-rich perspective could add. That's true even at the level of like reading a case, let alone thinking about macro forces in history and so on. The case method, I would, assert and be sympathetic to the idea that it screens out context, and it tries to confine you to understanding legal outcomes as following from legal materials in kind of a direct and determinative way. And I think that whole tendency is, in a sense, to screen out context and historical thinking, what it can add to legal thinking, even if legal thinking is always going to be what it is, because there's institutions engaged in thinking that way. Historical thinking is always useful because it helps denature that. And if you're a legal practitioner, you'll bring that mindset into your presumable future, and that's always powerful. Thank you.